Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale, a real-life case with real-life clients with real-life facts, though their names, of course, are altered for confidentiality purposes. Before we jump in, this is episode number 15, guys. I'm not sure where the last 15 weeks have gone, but time sure does fly, huh? It's fun for me to look back when I first thought, hey, maybe I'll start a podcast. And now today, we're on episode number 15. There was a lot of prep work that took place before the podcast even started. And truly each week, there's a lot of prep work done in writing and recording and scheduling. So I hope you all have enjoyed it and continue to enjoy it as much as I have. Let's get down to business, shall we? So today's cautionary tale is on a client that we're going to name him Brad. We're going to call him Brad. And when we met with Brad, he had started showing signs of a disease that he had been diagnosed with many, many years ago. And it's a serious hereditary disease called Huntington's disease. Before I continue chatting about Brad and what happened, I'm actually going to take a minute or two and talk about Huntington's disease itself, because I think it's really important to bring awareness and provide some education on it. And heck, maybe a Legal Tea listener learns about it and may be able and willing to support an organization that helps individuals and their families who have a Huntington's disease. Prior to being in the estate and elder law business, I frankly don't think I had ever heard of Huntington's disease. One day my office was contacted to be a guest speaker at the Huntington's Disease Society of America, their annual symposium for the Indiana chapter. And it was that invitation to speak that first introduced me to the term Huntington's disease. According to the Huntington's Disease Society of America's website, Huntington's disease is, quote, a fatal genetic disorder that causes the progressive breakdown of nerve cells in the brain. It deteriorates a person's physical and mental abilities, usually during their prime working years, and has no cure, end quote. It's the word fatal. It just stops me in my tracks. Furthermore, an element of Huntington's disease is that it's extremely hereditary. Oftentimes, Huntington's disease, people will refer to it as HD. So, from the Huntington's Disease Society of America's website, they explain this hereditary element as, quote, HD is known as a family disease because every child of a parent with HD has a 50-50 chance of inheriting the faulty gene. Whew. If you'd like to learn more about Huntington's disease, or maybe you want to check out your local chapter in your state, please head to hdsa.org. Or there's a direct link to that website. If you can't understand what I'm saying, HDSA, there's a direct link on our website for this episode's page on our website where I keep all source links for specific episodes. So if you go to Legal Tea's website, click on this episode, you'll see the source link there. So back to Brad. Brad landed in our office because as his symptoms continued to increase and surface, he recognized the need to get some basic documents in place, such as a living will, healthcare proxy, healthcare power of attorney, and financial power of attorney. And it was within that meeting and that conversation that we learned he was relatively estranged from his family. And instead of putting family members in these type of estate planning roles, he actually ended up putting some close friends of his. And to this day, when I look back on Brad's case, I truly think he chose the right people, because as the disease caused him to decline, his friends stepped right in and helped him just like they were his family. Like, for example, it was discovered that Brad had not filed taxes in nearly 10 years. Oops daisies, right? So the friend got a hold of us for a referral and kind of, wow, what am I supposed to do? And we got them over to a trusted accountant and got it all cleaned up. Check. So after we got his basics in place, the power of attorney, living will, financial power of attorney, attention then shifted to getting some sort of like last will and testament or living trust in place, mainly to ensure Brad's assets went to where he wanted after he passed away. There was some discussion of getting an asset protection trust in place to ensure his assets were protected if he had to go into some sort of long-term care facility due to the disease's impact on him. Another reason this was an important consideration was because Brad had shared about his estranged family and that he did not want his assets to go to them. Well, without an estate plan, when someone passes and their assets go according to the intestacy statutes, those intestacy statutes don't care if you have a relationship with people or not. It goes to family members. So I think I shared this before, but my estate and elder law world is filled with you can lead them to the water, but you can't make them drink at moments. I mean, only the client can drink the water. I can lead them there, but only the client can drink it, right? Well, Brad did not drink the water. I'm not sure why. Maybe it was because he didn't know who he would want as beneficiaries. Maybe it was because he thought he had plenty of time to decide. Who knows? All I did is he never did a will, never did a trust, nothing. Sometime later, we heard from his friends, the ones that he had appointed as his power of attorney, that Brad's condition continued to get worse. And as it continued to get worse, Brad's denial of his condition dramatically increased. It was so sad. So his friends, coming from a good, honest place, reached out to figure out what their options were. You know, we can option one, leave things as is and just continue to operate in his best interest. Or secondly, you could entertain utilizing a guardianship. And we presented those options and gave them, the friends, the space to weigh the options. And the next time we heard from anyone regarding Brad was that he had passed away. It was completely unexpected. It was only about a week after our last conversation with Brad's power of attorney about, leaving things as is or talking about a guardianship. It was only a week after that. So you probably know where this conversation is going. Brad made a great decision about getting those basics in place, like a living will, healthcare proxy, healthcare power of attorney, and financial power of attorney. After all, the friends of his that were willing to step in did a wonderful job. They got things organized, they helped keep things managed and keep things on the up and up. Without those documents, they would not have had the authority to help out. For example, after much work, you know how I was explaining that they got all the taxes all straightened out? I mean, just look at it from that perspective. Having that cleaned up will absolutely surely pay off for them. And that way the IRS won't be all confused when it's time to file his final personal tax return and eventually his estate tax return. I mean, it's pretty obvious that we never want to, it's never a good idea, right, to confuse the IRS. So, Brad never created any will or trust, if you recall. And all of his assets were in his name alone, and he didn't have any beneficiaries designated on those assets. So if you've listened to some of Legal T's past episodes, you surely know what this means, that Brad's estate is going to go by the Indiana intestacy statutes. And these funny named laws are built in the Indiana Code for individuals that pass away without an estate plan. Sort of think of it as a built-in estate plan for you when you don't have one. That sounds all fine and dandy, right? Wrong. Wrong. So the thing about the intestacy statutes is they're often not what you'd think would happen. For example, if you're married and have a child or children, if one spouse passes away, and depending on how assets are owned, then the surviving spouse is entitled to one half, and the children are entitled to the other half. So many people think, oh, everything will go to my spouse without a will. No, it won't. So how does the Indiana intestacy statutes work for Brad's estate? Well, you remember those estranged family members? Well, that's where it's heading, which breaks my heart. And now it's too late to change. It is going to go to them. And there's nothing his friends can do at this point. They're left with how Brad left things, which I'm sure made his estranged family members very happy campers. Furthermore, because no one is named in a will or trust to take over after Brad had passed away, everyone was sort of looking around and pointing at each other like, are you going to take over? Are we supposed to take over? And from what I gathered, the estranged family members wanted absolutely nothing to do with putting in the work to get Brad's estate administered. Because Brad's friends are just really awesome people, they agreed to step in and continue running with the baton on Brad's affairs. And these poor friends of Brad, all the assets got frozen on them, which is a relatively normal thing that happens when people pass away. So, like for the funeral expenses, none of the family members wanted to help chip in, or maybe they could not help chip in. So the friends, paid for it out of their own pocket. And side note, we did get them reimbursed, but still, right? Most states, and I wouldn't be surprised if all states allowed for this, allow for serving in these type of roles like executors, personal representatives, guardians, trustees, to be paid some version of a compensation. Indiana's standard is, quote, reasonable compensation. It's got to be reasonable. I often wish there was some like magical math equation to put numbers in and that equation spit out, here's your compensation rate. Well, there's not. It's a total gut check. I've represented people in these type of roles that get paid, like $15, $20 an hour. I've seen professionals serve in these capacities, like attorneys, accountants, financial professionals at their hourly rate. So, $200 an hour, $300 an hour. I've even seen people take X percent. So, if the estate value is $500,000, they're going to take 2% of the estate value. What you have to take away from this is there's so many different methods. So long as you can justify your fee and be willing to argue for your rate, even in a court of law if it results to that, that's what I mean by it being a gut check. If I had a non-professional client wanting to take like over $100 an hour rate, I'd recommend they rethink that decision. I had a client once take $75 an hour and his siblings fought him. So, because of the uniqueness of this situation, I recommended to Brad's family or Brad's friends that are serving in the executor role at this point that we get ahead of this conversation and have the beneficiaries of Brad's estate, so those estranged family members, agree to what compensation method and rate Brad's friends would take. And that way, it's not a surprise at the end of the estate administration, and no one can get their panties in a little bunch. So if there's any good in this story, I guess it's that we got Brad's friends, reimbursed for everything that they paid out of pocket for, which was not just the funeral, by the way. And they got compensated for their hard work, time, energy, etc. And goodness sakes, they deserved it. So yeah, here we are with another crazy real life story for you. I saw a client recently outside the office, and they were sharing that they had been listening to my podcast and had just finished the episode that my husband co-hosted with me on a few episodes back. And they were like, that story was really real? Yes, everyone. These cautionary tales are real life people that I or my office have helped. Who knew this wonky stuff happened in old Indiana, right? So anyway, for all you people that have estranged family members, please hashtag do your estate plan for your own peace of mind. To be honest, someone like me, an estate attorney, will be here to help you when you hashtag do your estate plan, and even be here when you fail to, and your family or your beneficiaries are going to probably have to pay more to someone like me when you fail to. So how about you just get it done? Next week's topic is a current trend, a current event, something I've seen or run across that I think would be fun and interesting to chat on here on Legal Tea. So next week will be fun. I got a lead from a team member of mine, shout out to Kara, who stumbled across a documentary on Netflix on Bob Ross, the artist that painted nature settings with a little afro. Now they have that little chichia pet thing. So anyway, specifically the documentary goes into the people in his life before he passed away and what happened to his stuff, his estate, and those people after he passed away. So until then, Legal Tea listeners, talk soon.